Hello, my name's Julie Williams. I'm the Principal Migration Agent for Migration Downunder, and I'm here to talk to you all about the Offshore Partner Visa, the Subclass 309-100. So what is the Subclass 309-100? It's a partner visa application for applicants who are in a relationship with an Australian citizen or permanent resident. Or perhaps you're the Australian citizen, permanent resident, and in a relationship with an overseas temporary resident. The best option is the 309-100 if you're residing together overseas. Sometimes it's the only option for those that are overseas and the visa applicant can't get another visa to enter Australia, but you're already married. You can't do an offshore de facto relationship visa if you are separated on an ongoing basis because of visa particulars and being in different countries. But the government does recognise married spouses that are separated. For example, perhaps you're from India, Pakistan, Bangladesh, where you have arranged marriages and you've got to have that commitment by getting married. And then the Australian citizen or permanent resident has to come back to Australia because of work reasons, jobs, etc., to make certain that they're all ready for when the visa applicant, comes out. The Australian government does recognise that. But the 309 is generally for people that are residing overseas, and then you can decide whether you want to apply offshore before you come to Australia, or maybe you only have the option to do that. So the processing is quite lengthy. You can expect in excess of 12 months. The more complicated or complex your situation is, the longer that's going to take. The requirements for the 309-100 is that you're in a de facto relationship. Either you have lived together for a minimum of 12 months, or you have registered your relationship if the country you reside in allows that, or you are married and there is no particular time frame that you have to live together if you are married. It's for all relationships. It's not just for male-female. It can be same-sex relationships, de facto or married, because Australia recognises all relationships. Now, what is the 309 and then the 100? Well, you're applying for a combined application, and if your relationship is greater than 3 years at the time you apply, then you will automatically be granted that permanent residency, which is the 100. Or you may be in a relationship for 2 years and you've got a child together or children together. Then you will also be eligible for that permanent residency. If not, if the relationship's less than 3 years or you can't evidence the 3 years of a relationship at the time you apply, they will assess eligibility to be in a genuine relationship and you'll be granted the 309. And then they'll reassess in 2 years from lodgement the 100 visa. It may not necessarily take a whole 2 years. For example, if the first stage is taking 12 months, then you only have to wait another 12 months before you're eligible for permanent residency. The government doesn't charge a second fee for that second stage application process. Some of the general requirements are that you have to be living together in an ongoing committed relationship. But as I said, there's some exemptions to that rule. If you are in an arranged marriage and you can't actually be living together for one reason or another, you also have to show evidence of household, nature of your financial commitments together, your ongoing future commitments, social aspects of the relationship, how you're recognised by family and friends. And you do need to be able to show that you've got a commitment to an ongoing relationship. So if you need to know more information, don't hesitate in getting in touch with us so that we can guide you and navigate you through what can sometimes be a daunting process. We try to simplify for you. So you can click on the link in our bio, visit our website, or you can always contact us via email or phone.